Okay, I think we'll go ahead and get started. Again, welcome to all of those of you who decided to join us this evening. We appreciate your taking time out of your evening. You will be getting a copy of the slides and also a link to the recording. Also, if you have questions, you can put them in the chat or in the Q&A. And we'll probably wait till the end to ask them to be answered. But if you have something that's urgent as we're going along, we'll try to answer it. So before we get started with the webinar, I'm going to give you a little information about SCORE. My name is Anita Kayat, and I am a SCORE mentor. And our speaker this evening is also a SCORE mentor, a subject matter expert, Tyler Bruley. I will turn you over to him as soon as we get through the SCORE slides. So SCORE has the largest network of free volunteer business mentors. We have over 10,000 mentors across the country. So if you have a business that we locally are not able to match a mentor with you, we can go online and find one somewhere else in the country. So if you're concerned that you have an odd business and nobody's going to be able to help you, I'm sure we can find somebody who can. Our mission is to foster vibrant small business communities, and we do this through mentoring and education. We hope that you, as a small business owner, will have all the support you need to be successful in your business. We do know that small businesses drive the national economy. Well over 90% of businesses are small businesses. And certainly in the Cleveland area over the last few years, we have seen some revitalization strictly owing to small businesses. We have people from all walks of life, and we're very pleased that about 10% of our clients are veterans, and over 50% of our clients are women. So a lot of women opening businesses. These are some of the statistics that we've accomplished. We were named Chapter of the Year of all the chapters in the country in 2022. We do cover a huge area along Lake Erie, all the way from Ashtabula to Erie counties, and we've just added Trumbull County as well. So our services are free. This is primarily because we get support from the Small Business Administration, but also because there are a great number of organizations within the Cleveland area that support us because they want to support growth for small businesses. I did want to make you aware that we are doing a networking event for our clients. It will be on September 12th from 5:30 to 7:30 at the Holiday Inn in Independence. You can sign up on our website. It's an opportunity to share your information with other SCORE clients and also with SCORE mentors. There will be a number of us there as well. So think about signing up and getting to know a number of your fellow clients. This is a snapshot of our website. You can sign up for a mentor, take a workshop, and you can review a lot of recorded webinars. There are a lot of local resources, which include templates like business plan templates, financial templates, articles about how to find an accountant or how to find a lawyer, a number of very useful things. So when you get a chance, take a look at our website and take advantage of the resources there. Now I'm going to stop sharing and I'm going to turn it over to Tyler Bruley. Tyler is an attorney and has graciously agreed to present this webinar tonight. So I'm going to shut up and let him take over.
Thanks, Nita. Appreciate that. So I'm going to go ahead and share my screen now and get this going. All right. I'm assuming everybody can see this now and can hear me. As she said, my name is Tyler Bewley. I'm an attorney. I practice business, real estate. I do a little bit of trademark law. I'm not a patent attorney. That's a very, very specific type of law, but I will talk about patents today. I'm going to talk about trade secrets and sort of in general, intellectual property as a whole. I am on the west side. I'm at a small firm. I used to be in-house counsel at an automotive dealership group, but now I'm in a firm, about 20 attorneys on the west side, Sealy, Savage, Ebert, Gurash, which is where I practice now. Without further ado, we'll move on. So I have to start out every presentation with, this is for educational purposes only. I'm not your attorney. There's no attorney-client privilege here going to be established tonight. You should consult your own attorney about each of your own very specific legal issues. And anything that I am going to say tonight is not to be considered legal advice. All right. So what should you expect in this presentation? Well, as I said, I'm a business lawyer. And so this presentation will be from the perspective of a business lawyer and from your perspective of what matters to me about intellectual property as a small business owner. What should I be worried about? What are the things I should be thinking about? What terms should I understand to be able to talk the talk and walk the walk in regards to intellectual property? And again, to take it one step further, when you should be concerned, right? So when should you seek the advice of an attorney? One thing I'm not going to do is I'm not going to go in depth into IP filing requirements, so what it takes to file a patent, infringement claims, or defenses, except for very briefly on trademark and copyright. And if you're at any of those stages anyways, so if you're considering filing for patent or infringement, or you need defenses because somebody's suing you for infringement, then you should already be seeking the advice of legal counsel. And lastly, you will not get specific answers to your specific IP issues tonight. I'm happy to talk about IP generally and answer general questions about IP, but theoretical scenarios that are very in line with your very specific IP issue, I will not answer at the end of the webinar. So what is intellectual property? What am I talking about when I say that? That is just a general term for a diverse category of intangibles. So what it really comes down to is rights in intangibles. So trademarks, patents, copyrights, trade secrets, they're not real things, right? They don't, I can't touch it, right? It doesn't exist. It's an intangible. And it can be fixed in a tangible item. So I can have a patent on a product and touch the product, but the idea is that these are all intangibles fixed, but they can be fixed in a tangible item and that are subject to ownership. So legal title and other rights under your state, federal laws, and in most jurisdictions throughout the world. There are a whole bunch of differing laws depending on which country you're in, and even among the states in the United States in regards to intellectual property. So again, just think about rights and intangibles. All right, so this is just sort of an overview of patents, trademarks, copyrights, trade secrets. There is something else called mask works, but we're not going to talk about that today. Those are like pictures essentially of, which is again, very simplistic version of it, the pictures to create circuitry boards. So we're not going to talk about that tonight. So there's 3 types of patents that you can get. The 2 main ones are utility and design patents. There are plant patents to protect new and distinct varieties of plants. So when you're thinking of like corn, you're thinking of different varieties of the corn when they genetically engineer them to be better, you can actually patent those under plant patents. So utility patents protect useful things, useful, non-obvious. That's what, when you think of a patent, that's probably what you're thinking of. And then there are also design patents that apply to the ornamental designs of manufactured articles. And really quick, I'll show you. These are just images of patents. So you can see this first one here. It is, it's really about the ornaments, not its functions, versus the second picture is referring to, and there's descriptions that we'll look at later, that's really showing you functions of it and its usefulness and how it works. So trademarks, think of names, brands, symbols, slogans, colors, sounds, package, and anything else to identify the source of the good in a relevant source of goods or services in a relevant marketplace. And those are, as we'll find out, are limited to a specific class of goods or services. So think of Amazon.com, right? Amazon is a trademark, but it only has that trademark in a specific class of goods or services. So if you're talking about the Amazon rainforest, they can't go and sue and say, we have the trademark on the Amazon rainforest. Coca-Cola, that's another famous one, Just Do It. Pullman Brown, you can actually trademark colors. So Pullman Brown is the UPS color that's trademarked. It's very rare to get a trademark color. It's basically like Pullman Brown and Tiffany Blue are the main ones you think of. And again, Energy Star, another good example. Copyright. So you're going to think of literary works when you think of a copyright, right? Protections on a book or something you wrote. So these are original works of expression in diverse categories. As I said, in books, computer software, recordings, audiovisual works. And then trade secrets. Usually what we're thinking about here is some kind of formula or recipe. So the Coca-Cola recipe, fracking, those the liquid that they shoot in to get natural gas out of the ground, that liquid is a trade secret. So these are the four things we're going to be talking about today. All right. So a little bit more into patents. So they don't come into existence the moment you create something. So the moment you invent something, you don't necessarily automatically get protection on it. You have to go to the US Patent and Trademark Office and persuade them to issue you a federal patent. And they're made up of what we refer to as claims, which are really like the borders that define what it is that you're claiming to be protected by the patent. And so things like the laws of nature, natural phenomena, abstract ideas, so just the idea of something, or simple mathematical formulas are all going to be exempt from being eligible for patenting. You can note that you can get both a design and a utility patent for the same thing. So you can get something that's useful and then also patent the design of it as well. So what it looks like. And then also note you can get a design patent and a copyright on the same things. It's very rare circumstances where you would want to do all of those at the same time, but it is possible. So more on utility patents. They protect useful inventions that are novel or new and non-obvious. Those are the three things you got to have. So they include processes, machines, manufactured goods, chemical, biological, and other compositions of matter, and improvements as to any of the above. They are good for a maximum duration of 20 years from the date you file, not the date that it's issued. So what does it mean to be useful? This can be difficult to overcome when you're trying to, because these are the things you have to prove to the US Patent and Trademark Office. You have to show them that it's useful, novel, and non-obvious. So you have to show them that it's useful, and it can be difficult, especially in software or medical applications. Ask yourself two questions. Does the invention work in the sense of, does it do the thing that I say it does? And if not, does the thing that it does benefit society in some way? Novel. Essentially, is it new? In this arena, is it prior art? That's kind of what we refer to it as. Is it prior art? And so there's a few subtypes. So, one, prior knowledge of the invention in this country, prior use of the invention in the country, prior patent in any country, prior printed publication in any country, meaning is this thing out there already? Is it really exist? Was it really yours? Did you really create it? Is it actually new? Those are the subtypes there. And then non-obvious. It must be more than a mere incremental advance. So it can't just be you going and saying, I've got the iPhone and it does this tiny little thing different, right? That's not a true new non-obvious invention, right? And this is one of the most litigated things. It's a factor test, meaning that it's a consideration of a whole bunch of factors to determine whether something is non-obvious or not. And here is a good example of a utility patent. So this is what it actually looks like. One of the pages, this is I think the first page of a US patent. You get a patent number once it's issued, the date of the patent. This is Steve Jobs' Apple patent. It looks like it's for some sort of highly portable media device. So I don't know if it's a remote or it has like a USB flash drive. But that's what that does. And then the abstract will show you kind of what it is. And so it says it's an improved portable media device and methods for operating a media device are disclosed. And then it'll go through, and I don't have them here, but it'll go through the claims of what it's claiming should be protected. So design patents. We just went over utility patents. These are the design patents. And if you remember, these are the things that protect ornamental designs of manufactured articles. And as I said before, which can also be subject in certain circumstances to copyright and trademark protection, known as registered designs in other jurisdictions outside the United States. So a design patent can give a peculiar distinctive appearance to manufacturer article to which it may be applied or to which it gives form. This new design should enhance saleable value, enlarge demand, and provide a meritorious service to the public. That's what you have to prove to the USPTO, that it enhances the saleable value of the article, it enlarges demand for the article, and provides a meritorious service to the public. And design patents are good for 14 years. And here is an example of one. Same thing. It's a Apple patent, I believe. I think Steve Jobs is involved in this one too. Yep, Apple Inc. So here's the claim, or this one just has one claim for it. The ornamental design for a power adapter as shown and described. And then there's a whole description here. It says figure 1 is a perspective view, because I'm just showing you figure 1 here. There's actually a bunch of different views, and it'll show you all the views and why they explain how it is a design patent. All right. So patent priority, how do you know who gets it? If a couple people have the same idea, it's first to file will receive the patent, assuming it's accepted by the USPTO, unless one of these two things occur. The claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So that's interesting because you want to keep this stuff secret, but if there's somebody else out there who files and they were already selling this to the public, they can get patent priority. And the claimed invention was described in a patent or in an application for patent that names another inventor and was effectively filed before the effective filing date of the claimed invention. So if it's already in somebody else's application. All right, so important dates. Public use and on sale. I've already sort of mentioned those two things. Public use is for the purpose of barring access to the patent system, is a use more than a year before the patent filing date, whereby a completed invention is used in public without restriction and in circumstances other than substantially for the purposes of experiment. And on sale is where an inventor has offered his invention for sale, has 1 year from the offer date to file for a patent application. So it's those 1 year marks. And failure to do so constitutes a complete statutory bar for patent protection. So as soon as you put it on sale, you have a year. You got to get it patented or you got to file that patent application within a year of you offering it for sale, or you're not going to be able to. So what are the benefits to a patent? So you get the right to preclude others from making, importing, selling, or using the invention for 20 years. Okay, that sounds simple enough. Let me just go get a patent on my invention, and I'll be able to use it for 20 years and stop everybody else from it, right? And not that simple. It's expensive to file. They're expensive to enforce because you do have to actively sue people to enforce your patent rights. And it can take years to get a patent. It can be a battle back and forth with the USPTO, both in trademark, copyright, and patents. So on to copyrights. Copyright does not protect an idea, only expression of an idea. So if it hasn't been fixed into a medium, it's not protectable under copyright law. So to be granted copyright protection, it must be original, meaning that it entails some minimal degree of creativity. Copyright exists from the moment the work is created. You do have to register. So you don't have to register. There is copyright exists under common law. You don't have to register federally to get protection. However, you will have to register if you want to bring a lawsuit for infringement of a U.S. work, the U.S. copyright. So registered works may be eligible for statutory damages and attorney's fees in successful litigation. So that's after you register it. And if registration occurs within 5 years of publication, it is considered prima facie evidence in a court of law. Copyright, with its term, it's the author's life plus 70 years, a lot longer than patents. You'll hear about in the news, the Mickey Mouse copyright. I think part of it, the very, very earlier iterations of Mickey Mouse are going to come off of copyright and become part of the public domain, I think, in the next year or so. So copyright notice is optional, but suggested to put others on notice. So example, copyright, you'll do a little copyright symbol, 2001, 2022, ABC Corp. Inc., all rights reserved, meaning that you put the 2001 is the date of first publication, 2022 is the date of any revisions, so you might have a few of those in there, and then your company name, and then reserving your rights. Expression of software code is protected by copyright, but not the functions of it. The DMCA, which is the Digital Millennium Copyright Act, everybody just refers to it as the DMCA, it added additional protections and made it illegal to circumvent technical protection measures online. So the encryption of files, there's even been more advances on this with the advances of like blockchain technology and that prevent access to copyright materials. And so the DMCA also contains additional penalties, including criminal and punitive damages if you violate it. All right, joint works. A work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So this is the example of you've got a partner in your business and you both create something, right? These are going to be joint works. And the copyright in a work protected under this title vests initially in the author or authors of the work. And the authors of that joint work, so you and your partner, are going to be co-owners of the copyright. The dispositive inquiry, though, is whether the parties intended to be joint authors. So intent is important here. And then what you want to look at is, one, that all participants were of the mind to participate, and that two, all participants contributed something inherently copyrightable. Any owner can authorize non-exclusive use without permission from others unless it damages the work, and profits must be split proportionately if you are in a joint work copyright situation. All right, so there's something called works made for hire. This comes up a lot in business situations. Especially with independent contractors, right? You're hiring somebody to do the design of something, produce some materials for you, what have you. These default rules or what's in the contract, and a little bit of plug. I'm doing another webinar on contract terms. I talk about this contract provision and what to look out for in it. I think that's next week. But work made for hire, you can get yourself in a situation where You know, you go to sell your business, or you need to do something with the IP, the copyrighted materials, and the next thing you know is you don't actually own it. Maybe the independent contractor owns it, and then you have to pay them again to go get it, right? So work made for hire is 1, a work prepared by an employee within the scope of his or her employment, or 2, a work specially ordered or commissioned. So that's what I was talking about, the independent contractor agreements. And it's a whole bunch of list of things that, you know, or could be works that are commissioned. And then finally, as I said, the contract, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. And that's important. You want to do that in your independent contractor agreements to make it very clear that you own this intellectual property, even though they're going and creating it for you, you own it. And if your work satisfies either prong, then the employer or other person whom the work was made for owns the copyright title. So copyright infringement. All right. Must show in order to win on a copyright infringement claim, you must show substantial similarity and access or evidence of actual copying. There has to be a material amount of expression, and it can be infringement if it has the same plot, theme, dialogue, mood, setting, characters, etc. You don't have to have intent here. And there's a common misconception. I didn't sell the copied work, right? So I didn't sell the book that I ripped off, so it's not copyright infringement. Wrong. If you take it and you didn't pay for it, it's going to be copyright infringement. If you're reproducing it in a way that you're not licensed to do or allowed to do, then it's still copyright infringement, and you can face some penalties for that. Contributory and vicarious infringement do exist, so you can contribute to this or do it vicariously through someone else. Copyright infringement. So there are defenses to copyright infringement. There are the fair use defenses, which are mostly what you hear about. And there's 4 factors to consider, and as I said here, it's clear as mud. As one of my professors used to say. So the 4 factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the work as a whole, the effect of the use upon the potential market for the value of the copyrighted work. So you can think of an example. A lot of times you can think of scholarship, teaching. It's where it comes up a lot, is education, right? So the purpose and the character of the use, right? We're teaching kids, this is good for the rest of the world, right? But at the same time, if you're taking money away from book sales, that could hurt the potential market or the value of the copyrighted work. Again, the nature of copyrighted work, it's educational materials, right? And then the amount and substantiality. So are you copying the whole textbook, or you just got like a 1-page copy out of it, right? Maybe that's fair use. Again, this is going to depend on the industry, right? There's not really fair use in ripping off a DVD, right? That's just going to be copyright infringement. But things like criticism, comment, news reporting, teaching, scholarship, research, those are all going to be usually fair use. So on to trademarks. So trademarks are, like we talked about earlier, Coca-Cola, the name, right? Just Do It, right? For Nike. Word, name, symbol, device, or any kind of other designation or combination of such designations that is distinctive of a person's goods or services, and that is used in a manner that identifies those goods or services and distinguishes them from the goods or services of others. So it's something that's distinct, right? And it can't be a functional element, right? That's for patents. It can be logos, words, certification mark, like we looked at with Energy Star. It can be trade dress, which is like product packaging, or product design can even be trademarked. You can use trademark to identify, you can use TM, sorry, to identify trademark, but can only use the R with the circle around it to identify a registered trademark. So you must register it to have the R there. All right, so once a merchant adopts and begins using a given device as a trademark, it does not have to take any further steps to protect the mark, as rights accrue to the first senior user automatically. So as I said, with copyright, you don't have to register to have protection. Same thing with trademark. There is some common law that gives you some protections. So if you're using it in commerce, you get protection where you're using it. So let's say I'm using, I don't know, some weird name for my business in Cleveland, but I'm only using it in Cleveland, and then somebody else is using, and I'm selling shirts, let's say, and somebody else begins doing it in Atlanta. I don't have any claims against them, and they don't have any claims against me. And further, I'm also probably going to not be able to get a federal trademark without some disclaimers around their trademark, and might even have trouble getting one at all. So federal registration is important, but you do get some rights with common law registration. So first use of a mark in a given market for a particular set of goods, services gets priority. So if there's somebody else in Cleveland that comes in and starts using that same name after me that I'm selling shirts, I get priority. I get the trademark there. But it does require bona fide sales of goods or services bearing the mark and limited to a category of goods. So if I'm selling shirts with a particular name, I'm going to get that as to selling those shirts. But if somebody comes in and has that same name, you doing cleaning services, I'm not going to have a claim against them. They're in a different channel of goods and services. All right, so register trademark. So you can get both a state registration, which would be protection in the entire state. It's rare to do this unless it's near impossible to get a federal trademark. Kind of mentioned that a little bit earlier. Federal registration, though, will give you protection in the entire country. And federal law provides for the intent to use registration as well. And this only reserves the mark. So let's say you haven't started selling t-shirts yet, but you're going to. You can get an intent to use registration and reserve the mark for your future use, but it's only a limited amount of time until you have to prove to the USPTO that, hey, I am actually using this mark, and here's my specimens that show me using it in commerce. So once registered, though, a trademark becomes incontestable after 5 years of its registration. So Just Do It, this is what it looks like on the USPTO if you were to search a trademark. Just Do It is Nike's, and you can see it's limited to these 3 classes here, 9, 35, and 41. And so it looks like it's got for downloadable virtual goods, and then it's computer programs featuring footwear, clothing, all the stuff that Nike sells, and then retail store services featuring virtual goods, namely footwear, all the stuff that Nike sells, entertainment services, namely providing online downloadable, all the stuff that Nike sells, right? Makes sense. Those are the channels of commerce that they're in. All right. And this was standard character mark. Let's see who filed it, whether it's live or dead, whether it's on the principal or supplemental register. All right. So what type of things are trademarkable? Generic or descriptive terms are not going to be allowed trademark protection. So Apple as an identifier for apples or Vision Center, right? Unless you can show secondary meaning. For example, 7-Eleven. There's a factor test for secondary meaning that we won't get into. The best trademarks, though, are fanciful, arbitrary, or suggestive. Unless they become the generic term for something, which you can lose your trademark protection. There's actually a famous one that just came out about Taco Tuesday. Apparently Taco John had Taco Tuesday trademarked, and Taco Bell filed a claim with the patent and trademark office said that, Taco Tuesdays become ubiquitous, right? You can't keep Taco Tuesday from the people, and they filed this hilarious complaint alleging that they should no longer receive protection, and they're probably right. And they, Taco John might have won, but Taco John pretty much just put their hands up and said, we don't want to spend the money to fight this. But that's why you never saw Taco Bell use Taco Tuesday as advertisement, but you will now. So what does suggestive mean? Copper tone or greyhound, right? It makes you think of something, right? But it's not like, something, it's just not descriptive words, right? Arbitrary or fanciful. So Apple computers, which is just arbitrary, right? Apples and computers, they have nothing to do with each other. King Arthur flour. Again, why does King Arthur have to do with production of flour? Things that are grounds for rejection are scandalous. So things that are inappropriate, right? You can't get trademarks on. Deceptive to consumer, geographically misdirecting, those kinds of things. So trade secrets. Information including scientific or technical information, process, procedure, formula, etc. These are going to be your recipes, like we talked about Coca-Cola's recipe. We talked about the fracking liquid. Those are trade secrets, right? And something is a trade secret if it meets this two-part test, and that's that it derives value from something being kept secret, and information that has been subject to reasonable efforts to maintain that secrecy. So if the Coca-Cola recipe ever got published, it would lose its trademark or its trade secret protection. So they're typically recipes, but they can be things like customer lists or processes. So Google's search algorithm. It usually involves employer and employees. So it's very important if you do have some kind of trade secret to make sure you have additional protections to keep it secret, right? Make sure your employees are signing agreements regarding them, making sure that it's locked up, making sure you have injunctive relief if your employee tries to tell somebody about it, that kind of thing, and limit the people who know it, right? And the best thing about trade secrets, and why a lot of times we'll want to choose a trade secret over a patent, if we can, or a copyright for that matter, is that there's no time limit on it. It lasts for as long as you can keep it a secret. So these are the three scenarios, though, where trade secrets can conflict with patents. So if an invention is clearly unpatentable, a trade secret doesn't cost us anything, right? That's the best part about it. It doesn't cost us anything, and it lasts forever. And these inventions wouldn't be in the patent system anyways, so it doesn't take anything from the public, right? Number two, if an invention is clearly patentable, the inventors will get a patent because the monopoly and protections are so much stronger. Because obviously you want to be able to tell people about your product, right? So it's hard not to get a patent there. And it protects against things like reverse engineering, right? So if somebody already knows about it, that's when it's really important to get a patent. And three, if there's uncertainty as to the patentability of some inventions, trade secrets are helpful to help keep those inventions from clogging up the patent system. So sort of what I said earlier about trade secrets, and that law being better than a patent in some cases. All right, so other IP concerns. IP concerns in contracts, confidentiality and NDA, security precautions. So IP concerns in contracts, I already talked about one, work for hire. All of those things, you really want to make sure that you're maintaining ownership. And if you are disclosing certain intellectual property to another party, that you have it in the contract that it's protected under a confidentiality or an NDA, so a non-disclosure agreement. It's very, very important, especially in things like trade secrets, to keep that stuff protected. And then security precautions, right? Making sure that all this stuff is under lock and key. All right, so I need to know more about IP, or I have a specific IP issue. A few great resources. Number one, the USPTO.gov has tons of resources on patents and trademarks. I mean, they've done a really good job over the last probably 5 to 10 years of updating that website for consumers. It's not written in a way that a lay person, a business person can understand it. It's really written so that they can understand. It's not written so that only attorneys can understand it. And the same thing with copyright.gov. Tons and tons of resources on there. You can search for patents, you can search for trademarks. Same thing, you can search for copyrights registered. So I really encourage you to go there. Lots of stuff to read. I think there's even videos. I think there's a whole series of 18 videos that'll walk you through all of IP. So if you didn't learn anything here, go there and you'll learn a ton more. And then finally, contact an attorney through either the Cleveland Metropolitan Bar Association, or SCORE has referrals as well. I already gave this plug, but join me next week for the legal webinar series on contracts, where I'll discuss different contract provisions and what they mean, including those regarding intellectual property. That is everything I have, and we have some time to spare.
Okay, well, we have some questions. First one, well, just a minute here. Where did it go? What's the threshold for when one should consider a trademark a unique business name?
Yeah, so if I understand the question correctly, what's the threshold? Okay, what's the threshold for when one should consider a trademark a unique business name?
Yeah, I'm not sure what.
So I'll just explain what I say to clients normally when we're trying to come up with a business name. You should do some basic searches regarding the name before you even create your business name. And so you should search, both your attorney or you should search the USPTO to see if anybody else is using it, to do a Google search, and to also go on the Secretary of State's website to see, is my business name actually unique, right? Does it meet the qualifications of trademark? And even more important, make sure that it doesn't infringe on anybody else's, right? Because the worst thing that can happen is you create a business, you got this cool name that you love, and you file it with the Secretary of State, and it clears the Secretary of State, and then you go, 5 years down the line, you're really successful. Well, somebody else already has that. They have the federal trademark on it. They, we're in priority to you, and then, come after you, and you have to end up changing your name, right? That's sort of the worst case scenario. So the earlier you can search it, the better. Like my firm does this when I file trademarks for clients where I'm looking for them. We use a service called Markify, and it does this crazy huge report that's 500 pages that searches every database known to man, and I go through those to make sure that the name's protected.
So there are lots of questions, really. Here's one. Content produced on news site is protected by copyright, but can a website itself, not simply logos, say logos used on it, be protected by copyright? Essentially, what web social media content can be protected by copyright?
Where are you looking? I just want to make sure I'm looking at the right questions.
Under chat, under the chat.
Okay, and which one are you looking at? Sorry, I'm a read. Okay, content.
Content produced on news site
is protected by copyright, but can a website itself, not simply logos. So there are there's domain protections. You can register your domain, right? That's protectable. You can get trademarks on the domain name itself, but not, you can protect the content that you publish on a website. So if it's actually original expressive work, then that is copyrightable. It automatically is copyrighted, and you can also register it, and it just appears on a website, but you can't copyright the website as a whole. Unless the entire thing is some original work. But usually it's not. Like if the tabs are, home and about us, right? You can't copyright that stuff, right? That's not going to be copyrightable.
Can a trademark be renewed after the 5-year expiration?
Yes.
Okay, there's also some questions in the Q&A. What is the current turnaround time for a trademark submitted today? I know changes are happening in September, if I'm not mistaken, with the USPTO filing system, perhaps due to an influx of applications post GPT. My second question is, should one expect their filing application after that change to take at least a certain number of months longer or shorter if submitted after the changes relative to a trademark application that would be sent in the next week or so?
Yeah, so I get this question a lot. Everything's slowed down in COVID. I think they're kind of caught back up. It really depends on which examiner you get, whether it's, a complicated trademark or not, whether it's easy for them to say no to it, or whether it's, a little bit more complicated on the edge, right? It really depends. It's not like a hard and fast rule, right? It's certainly going to take months. I don't know about the ChatGPT thing, of whether that's created a worse backlog or anything like that. I'm not sure.
Yeah, it's kind of interesting. So how is trademark common law enforced? Do they Google search for XYZ trademark word or phrase and then use the Wayback Machine to see if those users were using it in commerce, which would render a trademark application for the same name unsuccessful?
So remember what we talked about earlier. So if you want to enforce your trademark, you're going to need to register it, right? So you don't have enforcement rights under common law. You just have the right to say that it's yours, right? And then to go later and register it, but you don't get those enforcement rights until you register it. But as far as, I don't know who they is, do they do searches for XYZ trademark word or the Wayback Machine, see if those users are using it in commerce? And yeah, so as part of your trademark application, and so I'm assuming they, meaning the registers or the examiners, yeah, they'll do all kinds of searches. They'll also look at your application. There's also people who can file and say no, I use that first, right? There's sort of like a notice and comment period, right? And so there's I think that answers the question. Sure.
Yep.
Yeah.
I don't see any more questions. Looks like you've answered them all.
Okay.
So that's a good thing. So thank you very much for doing this webinar. It's a lot of good information. And actually, I think your follow-up on contracts is going to be wonderful for every client. We have too many clients who come in with a contract they already signed, or they forgot to put things in the contract that were critical to the success of their business. So I think this is one I absolutely encourage my clients to attend. So I hope we'll see everybody next week. And thank you all for joining us. Again, you'll get a copy of the slides and a